Well, welcome to discussing mental health in the construction industry. My name is Andrew Douglas, and I'm a managing principal who works in workplace law and specialises in wellbeing. Today, we're going to do three things. We're going to start off and talk about what is the evidence around mental health in your industry. We're going to then talk about what is the law. What do employers have to do? What are the expectations around employees? And then we're going to look at what are the solutions for you. And those solutions can be organisational or individual. The last few minutes, I've got a case study for you. So you can go and try and apply all the skills that we've spoken about. And at the end of that, you've got to answer a few questions. So see how you go with that. But let's start with the evidence, because I think one of the major problems around mental health is people don't understand how pervasive it is. The construction industry has the most vulnerable group of people working in it around mental health. That's the age group, skill base, and the risk rating of the individuals who work in the industry. And generally, the age groups are between 25 to 45. They have a high risk profile. So there's a higher use of alcohol and drugs in construction than in any other industry. And they're predominantly men. Now, the data around men seeking help is really alarming. When we look at EAP statistics, that is Employee Assistance Program statistics for men, what we see is really daunting. Around about 8% of EAP referrals are for men, the remainder are women. So that shows that men are 1 in 10 of the people seeking assistance in an environment where employment is around about 52 to 48% women to men. That's really quite alarming, isn't it? Not only that, in EAP statistics, we see that men don't often find much benefit from it and underutilise it, which can be contrasted with women. The least users of EAP are men between the ages of 25 and 45, which is your industry. So that tells us, if we look at general numbers, and the general numbers in our society is that 1 in 5 people will suffer a mental health issue that prevents them from undertaking the inherent requirements of their job each year. 20%, it's high, isn't it? If we look at our workers' compensation statistics, and there are very dramatic changes occurring in that. In the past 10 years, mental health injuries or psychological injuries which bring a claim in workers' compensation reflect about 6% of all claims made. That's up to 2019. But the nature of psychological claims for business is very expensive because although they represent a relatively low level of claims up to 2019, the cost of the claims once accepted is around about 2.5 times the claims cost of any other claim. So they actually make up a percentage of around about 15% of claims cost. Now remember, in a business, your workers' compensation premium, and in a builder, that's very substantial. And the reason why workers' compensation is substantial for builders is there are 3 core elements around premium measurement. One is total remuneration. The second is the nature of the risk that sits in the industry. And the third is the history of risk for that employer. And we know in construction, there is a high level of risk. This is a physical injury. We know that they are high remuneration businesses. The costs of employing people in construction are considerably high. And we know that most employers in construction have a series of claims that are continuing. So that means there is a very high premium. And premium, say for a $10 million construction business, $10 million remuneration, the premium may be upwards of $400,000 for each year. So an injury which doesn't get better, like a psychological injury, will impact throughout the premium period and could cost as much as over $1 million in premium. That's straight out of profit. In the construction industry, the margins are very low, okay? The margins are between 10 to 8%. And that's what's being taken away for every workers' compensation claim. So the business case for employers is absolutely compelling around mental health. But what's changed in the last 2 years with COVID and other disruptions in our workplace is we've started to see an escalation in psychological injuries. And the facts that cause that are that people don't deal well with uncertainty. People feel they need to be able to control their life. And the background to all mental health claims is a sense of loss of control. So we see it during other major stresses in life. We see it during grief when someone loses someone. We see it during separation from a partner. We see it through a loss of a job. They're the types of things that trigger mental health claims very commonly. But we also see it when people no longer feel safe in their work environment. So if we look in the construction industry, which is a week-to-week engagement often for people who are employed, there is enormous vulnerability. Am I going to have a job next week? When we get up this last level, is there another job waiting for me at the other side of it? These are big problems. And that level of disruption that's being caused through our world, particularly with COVID and other changes, means that the certainty we once enjoyed in 2019 has gone and it will not come back. What we saw in 2020 is a growth in psychological claims to 14.5%, and the cost of that being 3 to 3.5 times the cost of other claims. So we're now seeing psychological claims worth 40% of total claims costs. By 2030, it's estimated that psychological claims will represent 1/3 of all claims. So the discussion we're having today is not a moot question. It is a real question, and it's a real question for the men and women who work in construction, because they are the people who are most likely to suffer those psychological events, and they work in an environment where the discussion around psychological events, trauma, fear, apprehension, sadness, is least heard and is not supported. Whereas, in fact, in many occasions, it's seen as weakness. Now, in some of your sites, you'll have what are called the blue hats, which are the people you can go and chat to. But if the blue hats and production get in the road trying to get your supervisor to go and chat to a blue hat, for instance, it just won't work. Because the other thing in construction industry, for all the criticism that is focused on the workers, is that they are work focused. They are about production. The men and women in construction want to get the job done. And therefore, they have significant risks around all safety, but particularly around mental health. Now, I thought I'd give you that background because I think that's really helpful for you to understand. Psychological events are causing significant cost to business, okay, in workers' compensation. When someone goes off on workers' compensation, there is replacement cost as well. There's also training and supervision costs. So the loss of an employee who's been working with you for 6 months is around about the cost in on-costs of half of that employee's wage on top of the replacement wage. So you have two things happening in cost. You have the cost of workers' compensation going up, and it won't go down, okay? Because the other part of workers' compensation is if there is negligence, in other words, if you did this and failed to do the right thing and a claim may arise, the premium won't go down even if the person returns to work. And the second thing you have is this cost of replacement, training and supervision to bring the next person up to the skill and competence. Now, your employer doesn't understand that. This is one of the major problems around workers' compensation, is employers simply don't understand workers' compensation. They see it as a failure of the employee rather than as a failure of the business, and it's not. And that brings us to the second part of what we're going to talk about, which is what is the law? Up until 2015, the law was that unless someone told you they had a psychological problem, you had no obligation to do anything about it. Well, that certainly was the perception in legal circles. So unless I said to you, look, my name's Andrew Douglas, I suffer from depression, under discrimination law, you weren't obliged to make adjustments so that I could do the job. And that's the obligation under discrimination law. There are certain things that are protected in discrimination law. One is illness and injury. Once it's disclosed, the employer has an obligation to create reasonable adjustments so the employee can do that job. Now, in construction, we see that fail day in, day out, okay? But that's what the law says. The law says if you're injured or ill, the employer must assess you to determine whether you're fit to do the work. Now, in 2015, there was a case called Burke and Suncorp where it was held, so it's a precedent, that where a reasonable person could observe someone suffered from a mental health issue, the employer must address that mental health issue and make those adjustments. In that case, this was a young insurance clerk who clearly was withdrawing. He was sad. He was not attending work a lot. He was often late at work. He was seen to isolate, and they eventually terminated him for bad performance. And the court just said anybody could see he was unwell. How could you performance manage somebody when clearly it is a mental health issue? Your job was to determine what was the mental health issue. A case that came out shortly after that, called Grant and DPP, where DP is the Director of Public Prosecutions. Grant was a young solicitor. He'd suffered a spiral fracture to his right femur. For any of you who've had a spiral fracture, I haven't. It's meant to be one of the most painful fractures of all. It's inclined not to heal because it spirals down the bone. He developed chronic pain, and from that inevitably came depression. Now, I want you to think about that. How many people have got soft tissue injuries with chronic pain in the construction industry? Chronic pain is one of the major precursors to depression, okay? So just remember, this is your industry. This is very, very common in your industry because of the nature of the work you do. He started to fail to attend work. He failed to attend court when he was due as a solicitor. He became fractious, difficult, irritable, sad. And what the judge said in this case was, not only do you have an obligation once you observe this problem, a reasonable person observes it, but your next job is to actually set out and work out what they can do, what they can't do, and in respect of what you can't do, what is the adjustments you must make? And that's a plan, he said. You need expert help. You can't just make it up as you go. Now, this is the leading authority around mental health, and these cases both looked at safety legislation. So let's spend a bit of time on safety legislation, okay? One of these was an unfair dismissal claim I've talked before. One of them was an adverse action claim. It doesn't matter what the claims were. The issue is the person doesn't have to tell you anymore they have a psychological claim. The supervisors must satisfy themselves people are fit for work, and that's where safety law comes in. Now, safety law has three fundamental concepts that I want to deal with today, and then we'll talk about what happens if you get it wrong. The first concept is reasonable practicability. So remember, the next two concepts we're going to talk about are providing a safe work and monitoring health. Both of those have as a beginning, you must do everything that is reasonably practical to provide a safe place of work. You must do everything that is reasonably practicable to monitor health. Reasonable practicability has four elements to it. One, you must identify a hazard. Now, in safety law, the word hazard means a hazard that is known within the industry within which you work. Now, mates in construction are shouting it out loud. Mental health is an issue in construction. That means an employer and the officers of that employer know it is a hazard. Now, let's talk about what an officer is just for a second. An officer is a person who has control or substantial control of the business, okay? So that's a director. That is the lead person on a large site is an officer, okay? It means members of an executive like a CFO, a CEO. They're officers and they have specific duties, okay? But the most important thing is mental health is a hazard. The second part of reasonable practicability is to determine what is the level of risk. All of you know this, okay? It is about the frequency and the seriousness of that hazard in affecting people. Well, we know mental health is everywhere. It's very, very frequent. We know it's at least 20% in the community, and in the group of people who work in construction, it is significantly higher. We also know it has a high risk of serious injury and debilitation and can lead to death. Again, in the age groups I'm talking about, in men in the industry I'm talking about, the levels of suicide are profound and incredibly saddening. So we know it is an extreme risk. Once we know it's an extreme risk, we must apply the hierarchy of control and determine in that hierarchy of control, what is the control using the resources of the organisation? And that means the builders have to allocate resources that relate to mental health. But I can assure you, if I go to their budgets, I won't find that. I'll find money for PPE, money for a safety professional who works in the business, but I won't find the allocation of resources for mental health. Yet that is an obligation. The risk register in safety requires you to identify high-level risks and to allocate resources to eliminate it. And reasonable practicability requires the underlying proof that is occurring. So to do everything that is reasonably practical around mental health to provide a safe workplace means I must have a mental health plan in my workplace that shows how resources will be applied to ensure people attend work well, and if they're not well, how they are managed in a way so they can undertake their work and how they are supported in and out of work as employees. Now, do you have that? I guess the answer is nearly all of you will tell me no. But you've got HSRs, you've got people who can agitate this issue, you've got supervisors and managers who have family who are affected by mental health issues. How can it be so? How can we live in an environment where we know of a risk which is so real and so dangerous and we turn a blind eye? You see, this isn't just a legal issue, this is a moral issue. If I had my young grandson and we were about to cross a road and a truck was coming, I would hold my grandson so he couldn't walk on the road. Why? Because I love him. Because I can never let him be harmed. Yet in a workplace, when we see a risk, we let people suffer. I don't think that's a moral issue. I don't think that's a legal issue, sorry, that's a moral issue. How do we do that? How do we justify that as a reasonable behaviour? Why is it my child more protected than my co-worker? Surely if I can see a risk, I should manage it. Now that to me is just a moral argument. It's how we as comrades, when we're working together, support each other always. But it doesn't happen in the construction industry. We don't talk about it and we believe people have to be tough and strong. That's not true. It's immoral, but it's clearly unlawful, because by not doing something and having a plan and executing against that plan, we are breaching a primary duty under safety legislation. The second duty is to monitor health. Okay, that means supervisors and managers must be able to satisfy themselves that the people who work for them have good mental health and are safe to be at work. That involves them understanding what is the work, what are the inherent requirements of the job, and it means them having a knowledge of the people they're working with, therefore they must have a connection. Now, when you're putting floors on a building and you've got 5 days to kick out the boxing, to stick up the next level formwork, are you connecting? And the supervisor is in charge of ensuring those floors go up. But the law says the supervisors and the employer and the officers must have a system of monitoring the health of the employee and being satisfied they're fit to be at work. Well, do you have a system like that? Do your supervisors chat to you every day? Because clearly you can't just look at someone and go, I think they've got a mental health issue. The only way that can happen is if you talk to them. And it can't be full of bravado and, yeah, you're a man, get on with it. You've got to know people. Therefore, you've got to be able to have conversations. You've got to know what life events are happening in their life, because they are the precursors to mental health. And the builders have to provide a resource, because I don't expect the supervisors to be able to mentally help somebody who's got a mental health problem, because it's not their skill. They're not clinical psychologists. So you need supervisors who are comfortable to have a conversation and a set of skills behind them, not EAP, not sending them off-site, but to have somebody these people feel safe to have a conversation with, so we can work out how we manage and monitor their health so they're fit to be at work. Now, if we do that, this is the key. If we do it correctly, there can't be a workers' compensation claim. Okay? A psychological injury claim has 3 defences. 1, does the person suffer a psychological injury? 2, is work a substantial cause and connected to that injury? 3, if it's relating to performance, was there reasonable management action? Now, if we identify someone with a mental health issue at the beginning and we properly set up a plan and support them, then work will not be a substantial contributor. The claim will fail. So in money terms, that's a great outcome. But it's even a better outcome because you don't injure a person. It's a better outcome because there's no replacement costs, supervision and education costs. It's a fantastic outcome. So why aren't supervisors doing it? Because there is no system or plan. There is no support for supervisors and managers doing it. The purpose for supervisors and managers is to get the floors up. And young men, predominantly young men who work in that area, feel proud to work hard to achieve that. And they measure themselves by the speed at which they work. And the one thing we know about safety is this: a bad safety system is unproductive and dangerous. So the faster you go to get to the end, the slower it will get done in reality. That's the evidence. Now, if we dig down a bit more in safety law, we might find some things which are not so flash and create a higher level of risk for employers and for supervisors, managers, and officers. So a primary duty breach can be pretty expensive to business, $1 million plus, pretty bad. But reckless endangerment, that's much more serious. That's a crime. And that has a $3 million plus fine, and it has 5 years in jail throughout Australia. And what that says is, if I'm aware of a risk and I'm indifferent to it, I do nothing about it, and a person suffers serious injury or death, you're guilty of reckless endangerment. And anyone, a supervisor, manager, officer, can be guilty of that. So can the business. Why don't we talk about this? In Queensland, for instance, where you have a very strong prosecutorial part, there's been something like 10 to 12 reckless endangerment claims over the last 2 to 3 years. There's been about 15 throughout Australia, but it's Queensland's driving it most strongly, where people go to jail quite regularly. We've been pretty distracted over the last 2 to 3 years, or 4 to 5 years, with the model legislation and now COVID. But we're seeing in Queensland, Victoria and South Australia, and soon Western Australia, a much more active prosecution base, and we're starting to see a growth also in New South Wales. So let's use a test of reckless endangerment. Do we know of a problem that could cause death? Yes, we do, or serious injury. Are we aware of a person who is afflicted like that in our workplace? Probably, yeah. A supervisor probably knows, at least in their gang, 1 or 2 people who've recently broken from their wife, who've been drinking too much, who are a bit out of control, who are sad, who are exercising poor judgment at work, whose performance is bad. They've got that reasonable person test done, haven't they? They know they have somebody at risk. They do nothing about it. Or worse still, they go, "Are you okay?" And the person goes, "Yeah, I'm fine." They go, "Good, thanks. Okay, I've fulfilled my judgment. Tick." Well, no, you haven't, because the actual observations of that person demonstrate the contrary. And the person, as a result of being so depressed, so stressed, is so distracted, they injure themselves at work. Or they injure themselves doing a task, right, at work. Well, that's reckless endangerment. Don't run and hide from it. The supervisor's guilty of it. Supervisor goes to jail. Let's look at orbit drilling as a case. It's the first reckless endangerment case and sort of helps us define the elements really well. In orbit drilling case, a young man was a truck driver. He was asked to drive a very substantial truck. It was one that he had not driven before. Okay? He was given no chance to familiarise himself with the truck and the safety features of the truck. The truck had a problem with its brakes. Its handbrake would fail. He was directed to drive the truck fully laden down a steep, wet, slippery hill on a rainy day. The supervisor knew all of what I've just told you. The truck rolled and the young man was killed. And the supervisor was sentenced to jail, 20 months jail, of which was wholly suspended. Now, since this case, suspension has been lessened. People have spent time in jail. The managing director of the business was fined $250,000 at a time when the maximum fine was $300,000. The business was fined $750,000 at a time when $900,000 was the maximum fine, because all of this was known to the business, all of it. Isn't that the same as mental health? When you look at your work colleagues, you know who they are. The supervisors know who they are. But do they do something about that? Well, if they don't, and they have that knowledge, then it's reckless endangerment. Now, in your jurisdiction, there is only one jurisdiction that doesn't have due diligence tests, which is Victoria. Every other state and territory does. And in Victoria, it is an implied due diligence under Section 144, which means if the officers of an organisation have knowledge, then these obligations of due diligence I'm talking about are imposed. In every other state and territory, whether the officer has knowledge or not, these are the obligations of officers. Now, remember, they're the people who control the organisation. And they are to understand what are the risks in the organisation. Okay, well, mental health's a risk, isn't it? Do we all agree that is a risk? It is an extreme risk. They are to know what is the law that applies to that. Now, we're talking about the law now, aren't we? So they've got to know that law, and they've got to know the up-to-date law. They've got to be satisfied in relation to those risks that there are controls which are patent that will work. They must be satisfied in relation to those controls there are adequate resources, and they must allocate those resources. That is, they must be deliberate in how resources are applied to eliminate or manage that risk. And they must have up-to-date safety knowledge, not down to exactly what is in a SWIMS, for instance, but they must have significant safety knowledge as to how those controls are working, and then have an auditable system which reports to them the controls are actually working. That's what officers must have. And yet in mental health, I'm talking to all of you today, do you see that? Do you see it as visible? Do you think the leaders of your business have that level of knowledge? Well, my suggestion to you is it's unlikely. And I've been working in the construction industry as a lawyer now for 35 years, hence my age. Now, the last part is the Northern Territory, Queensland, ACT, Western Australia just recently, Victoria, and of course in New Zealand, there is industrial manslaughter. Now, industrial manslaughter is the most serious crime. You're all aware that that can be, in places like the Northern Territory, life jail. It can be 25 years in other places. It varies as to the severity of how long you can go to jail. It is always limited to the officers of the business. Okay, I want you to understand. No one else can be liable for industrial manslaughter except the employer, the company, and the officers of that company. Now, the elements of industrial manslaughter are very similar to criminal code manslaughter. You have to show a breach of duty. That's the primary duties that I've talked to. Monitor and provide a safe place of work, okay? So the absence of a system, that'd be a breach, okay? You must show there is gross negligence. That is negligence that is so significant that it's of a criminal standard. And you must demonstrate there has been a death. But the important part of industrial manslaughter is, unlike reckless endangerment, it doesn't have to be on the workplace. It can be outside of work. Industrial manslaughter was designed to deal with mental health issues because it's recognised that when you create a mental health issue, the person may die away from work for all the reasons I've described, being distracted, anxious, self-harming, whatever the reason is. It may happen away from work. And industrial manslaughter grabs that so long as work was a substantial cause. Now, did you know that? I guess that's my first question. Do the people who run businesses in safety understand that heavy burden? We're seeing charges being laid at the Canberra Hospital, which is still to be determined. We've seen recent charges laid in Queensland, okay? One that's been dealt with, one that's just recently been done. It's going to happen quicker because the regulators need to use the industrial manslaughter tool, because what they've found out is that individual deterrence works much better than just fines. So for the officers of organisation, be aware they are going to be knocking. Construction, given the nature of it, risks it has, okay? Working at heights, traffic management, demolition work, okay? Especially around things like form work. Crane work, which is where most of the serious charges have been laid. All of those things happen in construction. So the physical risks are very, very high in construction. But as I've said to you, the psychological risks are higher again. And since New South Wales introduced a psychosocial code of conduct, That is now going to be used as a test for what is reasonably practical throughout the rest of Australia. Now, in the Northern Territory, it's in a draft discussion stage. In Western Australia, the draft is out there for further discussion, and it replicates, but has some great case studies, what exists in New South Wales. So for all the employers who watch this, there is a code which is evidence of what is reasonably practical. If you do not do it, you'll be measured against it. And you're not doing it now. So you are failing now. That is the breach of duty. If what we can show is your ignorance, your failure to do something, we're so negligent. So let's use an example of that. I'm your employee. I come in smelling of alcohol. The supervisor says, "Hey, Andrew, are you okay today?" And I go, "Yeah, I'm fine. Absolutely fine." He goes, "We smell a bit of alcohol. You're still affected." No, I'm good. I'm good. He said, "Okay, well, you go and sit in the crib room for a couple of hours, and we'll do an alco test to make sure." And I go, yeah, that's fine. And then I say, and you haven't asked it, my wife left me the other day. I've been drinking like this for a couple of days. Now, can you tell what that says? If I start drinking because of a major event that's occurred in my life, I'm not coping. I'm not just a good old boy. I'm not just having a few drinks with the mates. I'm drinking to stop the pain. I'm drinking because I can't cope. After my 2-hour test, I go 0-0. Supervisor goes, "You're fine?" And he sees me in the crib room. I've got tears in my eyes. And I'm looking at a photo of my wife on my mobile phone with tears in my eyes. I don't seem to be listening to anything that he's saying. And he keeps saying to me, "Andrew, okay, it's time for you to get up on level 6. We've got to kick out the box work. You're able to do that? And we've got to set up form work on 7. You asked me 3 or 4 times, like, "Oh, yeah, no, I've got it. You want me to box? No. And you've got to correct me 4 or 5 times. I'm clearly distracted. I'm clearly anxious. I'm clearly sad. You direct me up there, and as a result of me working at height and trying to connect something up to lift to the following floor, in an unguarded area, I fall and die. It's industrial manslaughter. Absolutely clearly industrial manslaughter. Why? I should never have been at work. Reasonably practicability shows I should not have been working. I should have been assessed. Remember, when you have an awareness there is a problem, you need to assess and determine what you can do and can't do. I didn't do that. I could have done that, but I didn't. So I'm not a little bit negligent. I'm hugely negligent. And it caused death. That's industrial manslaughter. So now I've given you the tools, haven't I, around the law. Can I just say around mental health and privacy, each jurisdiction has a different method of managing privacy law. Some just sit under the privacy legislation. But what your mental health is at work is not subject or can't be controlled or prevented by privacy legislation. I'm entitled to ask questions around your health at work. I'm entitled to get answers so long as it relates to the inherent requirements of the job. Now, how I use that is subject to privacy law. I can't give that information to people who it's not relevant to. But don't ever tell me that what's happening in your life when you're at work is private, because it's not. And it's not protected by privacy law in the request I make for you to disclose. And it is a lawful and reasonable direction for me to make that request of you, because under all safety law, your obligation is to exercise reasonable care, that is, of a competent person doing their job, that's what reasonable care means, to prevent injury to yourself and others. So you cannot say, I'm not talking to you about it, because it's a breach of a lawful and reasonable direction. I've given you a lawful and reasonable direction. It's lawful because you're obliged under Section 25 in Victoria and similar provisions elsewhere to advise me of what your health status is so I can determine whether it's safe to work. Now, lawful and reasonable direction is protected under every form of employment law. So under Regulation 107 of the Fair Work Regulations, it is serious misconduct to fail to comply with a lawful and reasonable direction. It is serious misconduct to do anything that creates a serious occupational health and safety risk to yourself or others. Serious misconduct. At common law, which is the law that judges make up, it's a fundamental breach of your contract of employment. And of course, under safety law, it's a crime. So let's just stop all the tiptoeing around mental health. It is your obligation, and it is a criminal act not to ascertain whether someone is fit for work. And it is equally unlawful not to disclose it. Now, this is a tough gig in construction. How you have that conversation may appear difficult. And what I don't ever want to hear, ever, is people say that having a conversation around the mental health is a hard or it's a tough conversation. Nothing could be further from the truth. When you chat to your child when they seem sad, is that a hard conversation? No, because morally you know it's the right thing to do. You love the child. So it's not a tough conversation when you love someone. Why does it become a tough conversation when you don't love someone? Surely it's an easier conversation when you don't love someone. So this nonsense about tough conversations, this deliberately setting it up so people are apprehensive to do it, is such rubbish. Do we care about our colleagues? Yes. Do we have a legal obligation to care about our colleagues? Yes. It's not a tough conversation. It's the law, and it's the moral conversation you should be having. How do I have that conversation? It's not hard. Andrew, how are you going today? I'm fine, thanks. Okay. And everything you see is it's not fine. Then you just state your observations. I see you say it's fine, Andrew, but actually you're looking pretty flat and a bit sad today. You sure you're okay? Yeah, I'm fine. I'm okay. All right. Well, look, I'm going to drop by a few times, and if I'm still not satisfied you're okay, we're going to need another conversation. Okay? Gee, that wasn't too hard, was it? Check in on basic things. You'll know something. You know, I would be saying to my supervisors and managers, find out parts of people's lives. You say, how was the weekend? What did you do with the kids? Do you know, it's all those little conversations that tell you, that give you the warning signs, the red flags. I didn't get much done over the weekend. I just drank. Okay, well, that's a warning sign, isn't it? Oh, it's a terrible weekend. The kids misbehave. Something wrong with my wife. I don't know what it is. Okay, red flag, red flag. Gee, are any of these tough conversations, by the way? I'm not seeing them as tough. I'm seeing them as the conversations that good people have every day. So your choice really is between being a good person or a bad person. It's black and white. Mental health is not something you can turn your back on. These are people you work with and care about. These are people who deserve your respect and trust. These are people who deserve of you to apply the law and do the right thing. So that really brings us to the third part of where we are today. We've talked about what is the evidence. There's a compelling case there, isn't there, for employers to do something, because it's going to cost them and it's going to hurt people. So compelling case. The law is, it's not only a compelling case, it is what they must do, not what they'd like to do. And if they breach that, they could be in jail. And not in jail for 10 days. In Northern Territory, they could be in jail for a long, long, long time. So what are the solutions? Solutions aren't hard. I've given you some of them, haven't I? But the first thing is to identify, well, what are we going to do about mental health? Are we going to have blue hats? Are we going to have peer groups that support each other? But you need a plan. And to do that, you must do a risk assessment. To do a risk assessment, you must collaborate with the people on site. Remember, whenever you introduce a change in the way something is done, there are two obligations that require consultation. One is all safety legislation requires that consultation. And in safety law, you must do it with a risk assessment to determine what is the appropriate outcome. You can't just talk to people. It's got to be based on risk and reality. Under your award, it is a substantial change in what we're doing. And therefore, again, it requires consultation, which is the delivery to people of what is the idea to discuss with them and their representatives. Now, both those things seem a really good idea, don't they? I think they. But you weren't meant to do that as a matter of law. So step one is to actually do a risk assessment. That may be begin with a simple survey that has 5 or 6 questions in it and trying to get people to respond. You won't get a lot of responses, but it's a start. It may be by having some smaller focus groups where you raise the types of issues which are the precursors to mental health and get people to talk about what they've observed and seen. In then forming your own specialised risk assessment by your safety people, of going and consulting on that risk assessment with the individuals in the organisation and saying, look, this is where we see, this is the process we're thinking about, we're thinking of bringing in a peer support system, we're going to build the skills of our supervisors, the supervisors are going to communicate you on a more regular basis to check in on your health. We're providing a specialised psychological service to back people, which you can seek referral to without it being disclosed to the employer what the nature of that was. You may have a whole range of things that do it, but you've got to have a system. It's got to be an unbreakable system, and it's got to be a system that everybody knows. But where's your best spend of money in safety? 2 places. Unquestionably at your supervisor level to build their skills, to build their awareness of what the safety law risks are for them, what is the intent of safety law, which is to stop people being hurt. It's not to save money, okay? Safety law came in the 1970s, and the guy who created it was a lord in the Privy Council, and he was a mad, crazy right-winger. And he did a whole lot of studies, and what he found out at the end of those studies was that a safe workplace is the most productive, most profitable, and the happiest. Now, he wasn't interested in finding out too much about happy, but then he made the connection. If you are safe and happy, you won't injure yourself. You'll be more productive, and it will be better for the employer. That's what drove safety legislation. 2 elements: productivity and profitability, physical safety. Okay, now mental health is bigger than that. Okay. But I want you to understand that's how safety law started. So the intention of safety law is to ensure people don't get hurt. That's the intention. And the benefit for business is it is much more profitable for them to do it well than to do it badly. And I've already told you the business case that sits behind this at a very low level. So training our supervisors on what are their obligations is important. But the second part is to give the supervisors a toolkit that they can do something to be trained with. In other words, this is how I want you to talk to people. This is the feedback loop to your managers. Okay, so you're going to chat to each one of your employees. You're going to come and speak to me once a week for half an hour and say how you're going with your employees and what's their health like and what are the big things happening in their life. So you can demonstrate to me you have this connection and engagement. Great stuff. But equally, if something goes wrong, you've got tools in your bag that you can respond to that person who's struggling immediately. The inability to respond leaves a supervisor powerless. A supervisor is powerless, won't intervene and respond. So 11 a.m. The 2 things which are really important in this are, 1, at an officer level, ensuring there is a system that provides them with the due diligence cover so they can't be prosecuted and the employer can't be prosecuted, and they apply such resources in a deliberate manner which are understood by their supervisors that the supervisors can deploy to their employees to prevent them from becoming unwell and dangerous to themselves and the business. That's pretty easy, isn't it? Because every one of those tools is available on the internet today. There's a million great resources that talk about how you do this successfully. There are some great practitioners who can actually help you build this system. But what you've got to get away from is this manly bravado that says mental health is weakness. Get on and do your job. That's the best way of getting better. All that stuff, all that crazy man stuff that damages and hurts people. It's got to change, because these are your brothers and sisters. These are the people you care about. If we want to make a difference in life to the people we care about, we manage their mental health and well-being. We want to make a difference to business, we do the same. There is a shared responsibility and shared benefit in what I'm talking about. For businesses, more profitable, better skills retention, happy workplace who do what you ask and support you. The individuals involved, much better mental health, happier life, better relationships, less drug and alcohol usage, and chances to grow and develop in the businesses they love doing. There is no bad story in looking after mental health. It's all upside, as long as we can walk away from the myth of manhood that damages the construction industry. Now, let's go on and do the case study. I've lectured you enough. You're sick of being told about it. So let's see how good your skills are. On your screen now will come up the case study, and I'm going to read it to you, and then you're going to have to answer some questions. And after you've answered the questions, I'm going to tell you what the answers are. So if you don't answer them right, don't worry. Nobody knows it's you, okay? So here's the case study. Jamie was a rigger working for High Rise Construct Proprietary Limited. His job was to remove formwork, including boxing, as they built levels in multi-storey buildings. So some riggers do that, some riggers don't, but that's part of this rigger's job. Jamie was an ex-footballer who played for the Nightcliff Bombers as a wingman. He was famously sacked from the club after kicking an opposing player and being suspended for 12 weeks. Jamie's foreman, Rod, was the son of the owner of High Rise and was a board member of the Bombers at the time of the incident. He got Jamie the job. Both Rod and his father, Victor, knew that Jamie had a concussion syndrome called chronic traumatic encephalopathy, or CTE. Caused him to be sad, emotionally volatile, including crying and forgetful. It was clearly one of the causes between his wild act on the footy field. Rod knew other employers regularly mocked Jamie, as he had lost all his toughness from football, drank too much and would often cry after he drank. At work, he appeared sad, withdrawn and vulnerable. Jamie clearly suffered from depression arising from the CTE. He never told anyone, but all his behaviour suggested something was very wrong. Both Rod and Victor were directors of the company, which is High Rise Construct, and knew that Jamie was struggling. They also knew he was regularly teased and taunted. Rod would often tell the guys to stop, but never disciplined them. He was kind to Jamie, but when that was seen by other employees, they treated Jamie even worse. Jamie's wife rang him one day when he was in a crib room having lunch to say he was leaving him and going away with his best friend. Jamie started to cry uncontrollably. The men around him laughed, calling him baby and little crybaby. Jamie was very distressed and went to leave the site. He walked across a no-go zone where a large cement truck reversed over him. There was no control of the traffic management system ensuring pedestrians could enter the no-go zone. Jamie was killed instantly. The coroner found he was distracted by the pain and anguish of the behaviour towards him, compounding the deep felt pain of his wife's rejection. All right, now I'm going to bring up the poll, and there are 4 questions. So now start working on that, and you've got a few minutes. All right, let's answer the questions and see how you went. The first question was Jamie being bullied? Okay, well, let's look what bullying means. And remember, bullying is just a very serious form of misconduct. If I'm rude to you one day, it's still misconduct. But in bullying, I need repeated conduct. So it's being rude to you every day or every second day, but it must be repeated. It must be objectively reasonable. That means it must hurt, humiliate, or intimidate. And it must affect your safety at work. So the first question was Jamie being bullied? The answer is yes. Unquestionably yes. But that's very important for this problem, isn't it? Because that's a state of knowledge which is enjoyed by the business and by Rod and Victor. They knew he was being bullied. And if I can just say to you, that comes to question 2, did High Rise breach? It should be its primary duties under safety legislation Well, it knew bullying was occurring. That means it knew there was a hazard occurring, and it knew it was a high risk given the vulnerability of the person. And the failure to discipline and take serious action meant there was no control over it. So there's a clear breach of duty. Okay, we're looking at 1.5 million fines possibility. The third question is, could High-Rise, Rod and Victor be charged with reckless endangerment? Now remember what reckless endangerment was. Were they aware? Okay, and this could also include the supervisor, by the way. Were they aware of a hazard that could give rise to serious injury or death? The answer is yes. Okay, that's the first part. Question one. Were they indifferent to that risk? Now, remember what I've said in the past. Telling people to stop doing something is not taking an action. Being kind to him is nice, but it's not taking an action. It is evidence of indifference. It's a carelessness about the ultimate result of what could occur. And finally, did he suffer injury or death? The answer, serious injury or death, the answer is yes. So it is no doubt at all that the supervisor, not in this question, but be clear about it, the supervisor, Rod and Victor, could all be charged with reckless endangerment, as could the company, which means up to 5 years jail for every one of them and significant fines for the business, up to a bit over $3 million. Now the big question, could High-Rise, Rod and Victor, now remember Rod and Victor are the only people because they're officers, only officers can be charged under industrial manslaughter. Could they be charged with industrial manslaughter, or as it's called in Victoria, workplace manslaughter? So let's do the analysis again. Was there a breach of duty? We've already agreed there's a breach of duty. Okay, there's a failure to comply, failure to provide a safe place of work. Reasonable practicability never occurred. Okay, so we know there was the failure to exercise all the reasonably practical elements, those 4 elements, to prevent an injury at work. So primary duty breach, hands down. No system, breach. No monitoring, breach. Okay, so very clear breach. The next question is, was there a gross negligence? In other words, knowing all these things occurred, knowing all the risks that sat there, were they grossly negligent? Was there something that they could do? Now, the question here is, maybe Rod and maybe Victor didn't know about the wife, but they did know about the teasing and taunting. They did know that he was a person who was regularly teased and taunted. They did know about his psychological vulnerability, and they did nothing about it. They were careless. Their only defence in this case is going to be, I didn't know about his wife leaving him with his best mate. And I can tell you now in a court, that's not going to go too well because they did nothing at all to protect him. Then did he die? Answer is yes. And there's a coronial finding that says that the cause of that death, see, negligence is a causation-based thing. There's no other part that has causation in safety legislation. Industrial manslaughter requires causation. The behaviour of not doing anything to protect this man caused his death. Yes, it did. Coroner said so. So in the Northern Territory, that could be life's jail. Wow. And so it should be. Because it was easy to look after Jamie, wasn't it? It was easy to ensure that he got proper treatment and support. It was easy to determine what adjustments could be made under DPP and grant. What could he do? What couldn't he do? What did he need to support him? They knew what was wrong with him. Now, maybe the right decision was not to employ him. Maybe that was the right decision. But they did. And in doing so, they placed his life at risk. And by failing to manage any of the incidents that arose afterwards, they pushed him towards his death and would be guilty. So today I want to be very clear, the management of mental health is not hard. It is good for business and it's great for employees. So why aren't we doing it? And in a case like this, not unfamiliar in our workplaces, you can see that high rise and its officers, and the last one, it's in reckless endangerment, its supervisor, could all end up in very serious trouble with jail terms for individuals and massive fines. But the saddest part of this story is that Jamie died. The saddest part of this story is that Jamie suffered pain because of the way he was treated for so long. And the question I want the men and women who are watching this show to do is that moral? Is that who we are to the comrades we work with? Do we treat people we work with worse than people we love? Thank you.